All rise.
Be seated. Oops.
Kosovo Specialist Chambers is now in session.
Madam Court Officer, please call the case.
Good morning, Your Honors. This is case KSC BC 2020-07, the Specialist Prosecutor versus Gucati and Haradinaj.
Good morning, everyone, and welcome. Any change in the prosecutor's staff?
Good morning, Your Honor. Benjamin Dearden, legal intern, is not with us today, but otherwise same appearances.
Thank you. Mr. Rees?
No change, thank you, Your Honor.
Mr. Warboys?
No change, Your Honor.
Mr. Buckley is with us on video. Can you hear us okay, Mr. Buckley?
I can, Your Honor, yes.
Thank you. We also note for the record that Mr. Gucati and Mr. Haradinaj are present in the courtroom. Let's first address the SBO request filed yesterday. For the benefit of the public, I will provide a brief summary of the background of this issue. On 5 November 2021, the panel ordered the defense to indicate within 5 to 8 days, after all matters under Rule 102.3 were solved, whether it requested further cross-examination of SPO witnesses. On 7 December 2021, the panel ruled on the last outstanding matter regarding Rule 102, sub 3. On 8 December 2021, the Gucati defense requested to recall witnesses 4841 and 4842, that is, Ms. Pumper and Mr. Jukic. Yesterday, on 9 December, the SBO filed an application in relation to Mr. Rees' request. The SBO filing is F-485. The SBO submits that there is no basis to recall the two witnesses because, first, there is no indication that either of them have any personal knowledge of the information in the Rule 102.3 materials, and second, on the basis of the defense evidence submitted and heard, it is now established that neither accused was entrapped. The SBO requests the panel to either preclude any further questioning of those witnesses or regulate their recall within the following limitations. One, that the defense provide in advance a summary of the scope of questioning of these witnesses and the relevancy of the intended subject matter to the issues before the trial panel. Two, that all evidence concerning the Rule 102.3 materials is to be elicited in private session. And three, questioning on all other subjects should be disallowed. First of all, I'll ask Mr. Rees if he has any comments on these submissions.
Firstly, we do not accept the proposition the SPO make that the evidence of Husni Gucati, as they put it, disavows entrapment. The SPO are under the misguided misunderstanding that coercion is a necessary element of a plea of police incitement. It's not. I won't go further into that. We've made our submissions in law that we will return to in closing submissions very clear as to what the elements and ingredients of a successful plea of police incitement are. But coercion is most definitely not one of them. We have been invited throughout by the trial panel, and we are grateful for it, to proceed expeditiously and to avoid delays where possible by being flexible as to, for example, the fact that the SPO have not fully complied with their disclosure obligations by the outset of the trial or by the point at which the conclusion in an ordinary sense of the evidence of Ms. Pumper was reached, or having completed their disclosure obligations by the point at which the evidence of Mr. Gucati would ordinarily have been completed. And we, although we had reservations and concerns about that, we raised it with the trial panel, who encouraged us nevertheless to try and make progress without insisting on a delay of proceedings until those disclosure matters were dealt with. Seeing that the trial panel were prepared to be flexible, we followed that course, and we hope that we did so with a view to ensuring that these proceedings took place expeditiously and as efficiently as possible, despite the delays caused by the SPO in repeatedly misunderstanding their disclosure obligations, as they clearly do now, still not understanding the true scope of a plea of police incitement. In relation to the two witnesses and their ability to assist with the matters that have been disclosed, with the final ruling on Rule 102.3, at least at this stage, and at least as far as any outstanding challenge is concerned, only being provided to us the day before yesterday, and us promptly indicating at the request of the trial panel that we wished to have the recall of the witnesses Zdenka Pumper and Miro Djukic the following day, not standing on ceremony in the 5 to 8 days that the trial panel allowed us to do. Despite our reservations about their ability to assist, they are the only witnesses the SPO have made available from within their ranks that in any way would allow us to explore properly and effectively our plea of police incitement. As the trial panel has observed in a number of rulings now, reflecting the jurisprudence of the European Court of Human Rights, it is essential that in cases where a plea of police incitement is raised, that the prosecution provide both disclosure and access to such witnesses that are capable of testifying on the issue as to whether police incitement occurred. Whether the SPO take advantage and follow the guidance from the SPO, from the trial panel, sorry, reflecting the jurisprudence on the European from the European Court, is a matter, of course, from the SPO. As they have put forward those two witnesses, and as the trial panel have invited us to request the recall of those two witnesses, in order so that we can press our cases fully as we are allowed to, with the restrictions put in place by the SPO to pursue our plea of police incitement, we have requested their recall. It may be, as the SPO says, these witnesses cannot assist in any way, shape or form. We will find out on Wednesday morning when they are recalled, and I ask them questions whether they can or not. If they cannot, so be it. And we will make our submissions in due course that the SPO and the trial process in this court has not provided us with the ability to effectively raise the plea of police incitement. If they can assist, then we will find out when they are further cross-examined on Wednesday morning. I intend my cross-examination, further cross-examination, to be restricted to the issues raised in the further disclosure that we have received since they were previously before the court to give evidence. I do not intend to go on a voyage in relation to other issues unrelated to those disclosures, unless I can assist any further in the circumstances, Your Honour.
Nothing to add, Your Honour. However, I do adopt the same position as Mr. Rees.
Thank you. Mr. Howling?
Briefly, Your Honor. Thank you. The arguments that we made in this filing from yesterday are arguments of evidence and substantive law. There are currently no outstanding disclosure requests in this case. They have all been complied with. The restrictions referenced by the Gucati defense, we don't know what they are, but whatever restrictions on disclosure have been imposed on the order of the trial panel following requests of the SPO. The only point I would like to reference now and to emphasize in our filing is in relation to the alternative relief sought if this is happening next week, and in particular the point about private session with these materials. We want to emphasize there is no margin for error with these materials and the questioning of these materials. This week, the trial panel gave a direction to the Gucati defense about names that they used in their opening statements, about things that had been said before. There was a filing of the Haradinaj defense that had to be reclassified because the name of an SPO staff member that's been consistently redacted in these proceedings was made briefly available. And there were 14 redaction orders this week during the testimony of the accused. These Rule 1023 materials are highly sensitive for reasons that have been discussed throughout the trial, and we are concerned that there is going to be a retrospective misunderstanding or something that the gallery hears and it maybe won't be broadcast, but these issues are very important to us in our investigations, and we would just ask that the trial panel bear that in mind when deciding on the modalities of any recall. Thank you.
Thank you, Mr. Halling. We've heard your submissions. We want to spend a little bit of time more examining the issue. We will make a ruling yet today so that you can prepare for next week. So hopefully at the next break, we will make that determination and give an oral order in that regard. Today, we are ready to continue with the next witness, who is number 1245, Mr. Chele Gashi. We will address the matter of his statement as we go, as we have in the past, following the steps of Rule 154. Madam Court Usher, would you please bring the witness in?
Your Honor, Mr. Bowden will be taking this witness.
Pardon me?
Mr. Bowden will
Thank
be
you.
taking this witness.
Thank you. Good afternoon, Mr. Gashi. Can you hear everything all right?
Yes, again, good morning.
The text of the solemn declaration which you will be asked to take pursuant to Rule 141, paragraph 2 of our rules. Please proceed. You have to, and please read it aloud.
Subject to Rule 141.2, conscious of the significance of my testimony and my legal responsibility, I solemnly declare that I will tell the truth, the whole truth, and nothing but the truth, and that I shall not withhold anything which has come to my knowledge.
Thank you, Mr. Gashi. Please be seated. You can remove your mask.
Splendid.
If you wish, you can remove your mask. Mr. Gashi, today we will hear your testimony. As you may know, Mr. Bowden will go first, and he will ask questions of you about your statement. Then the court will issue a brief order regarding your statement. Once that is done, the admitted part of your statement will be read into the record. Then Mr. Bowden might ask you some more questions if he has any, and next the lawyers representing Mr. Haradinaj may ask some questions as well, and then it will be the prosecution's turn to ask you questions, and the members of our panel here may ask you questions as well. Mr. Bowden estimates his examination will be short, perhaps 15 minutes. The prosecution will have a longer time cross-examining you. They've estimated as much as 2 hours. The panel may also allow re-examination by the defense counsel if conditions for it are met. Please try to answer the questions clearly with short sentences. If you don't understand a question, feel free to ask counsel to repeat the question or tell them that you don't understand, and they will clarify. Also, please try to indicate the basis of your knowledge of facts and circumstances that you will be asked about. Please also speak into the microphone and wait 5 seconds before answering a question and speak at a slow pace so the interpreters can catch up. While you are giving evidence in this court, you are not allowed to discuss with anyone the content of your testimony. If any person asks you questions outside of this court about your testimony, please let us know. Mr. Bowden, please first ask the witness if his statement accurately reflects what he would say in court, and then the panel will render its order, and then you can read what is admitted, and we can continue with the examination. Go ahead.
Thank you, Your Honour. Good morning, Mr. Gashi.
Good morning.
Full name, please.
Cel Gashi.
Of April 1966.
Yes, the 5th. That's correct.
His statement.
Certainly.
Mr. Gashi, the statement is printed on both sides of the paper, so it's 3 pieces of paper. And I note that, Your Honour, the Albanian and the English versions are being displayed. Mr. Gashi, can you confirm that you've previously had the opportunity to read through that statement? You've previously seen the statement and looked at it and its contents. Is that correct? Thank you.
Yes.
The final page of the statement, so the 3rd page that you have before you, which will be shown on the screen also.
Okay.
You will see a name and a signature and a date of the 15th of July of 2021. Is that correct?
Yes. Yes.
Spoken about the contents of the statement. Can you confirm that the contents are true?
That's correct.
The statement accurately reflects the evidence that you would wish to give to this court. Is that correct?
with the exception of 2, 3, or 4, which might be slightly wrong.
Paragraphs 2, 3 and 4, or 2, 3 and 4 matters?
It's on the hours. It says 2 or 3 hours. That might be wrong. The time of reading, that is.
Your Honour, I believe that's paragraph 14. If we get, Your Honour, the approach, I think, as suggested yesterday, and I hope that that is still in agreement with both the SPO and the trial panel, would be if the statement is read, there are certain paragraphs that are not to be read, which we would propose to deal with by way of oral evidence, and I would propose to stop reading at the appropriate time and then ask Mr. Gashi specific questions at that time with the trial panel's approval, as opposed to dealing with the matters at the end of the statement, not chronologically in order. If the trial panel agrees with that approach, perhaps I can conduct a similar approach with regard to paragraph 14 and not read paragraph 14 in the light of the indication given by Mr. Gashi.
Mr. Warboys, is that acceptable to you?
Of course, Your Honour.
Mr. Hulling?
Well, Your Honor, he said 2, 3, or 4, and he's only mentioned 1. We would say that the proper procedure here would be for the witness to clarify each of the points of the statement that don't correspond to his current recollection, and then our objection remains on those 2 paragraphs which we say should be elicited orally without a summary read first.
Well, we'll deal with those 2 paragraphs, but try to nail down exactly which paragraphs he now is suggesting he disagrees with.
Mr. Gashi, when you mentioned when I asked you about the contents of the statement and if it accurately reflected the evidence, you mentioned that there were 2 or 3 things. When you say 2 or 3, what do you mean? The 2 or 3 that you've mentioned already, or is there anything else?
It's paragraph 14 where it mentions 2 or 3 hours.
That was the one amendment you wish to, or the alteration.
And somewhere else there is a mention of 4 hours too, which I can't find at the moment, if you allow me some time.
I'd suggest we find that.
Yes, thank you, Your Honour.
Paragraph 28.
Paragraph 28, yes. Well, perhaps, Your Honour, with the trial panel's leave, I can conduct similarly an exercise to deal with paragraph 28, and paragraph 28 will not be read.
So 14 and 28 are the 2 paragraphs that this witness has indicated might not be correct, and I would suggest that 14 and 28 not be read, but be subject to direct examination and then possibly cross-examination. All right, Mr. Halling?
For those paragraphs, no problem.
Okay.
Mr. Gashi, then, with those, I do apologise.
No, go ahead.
With those amendments, can you confirm that the remainder of the statement accurately reflects the evidence which you would wish to give to the court? If you could just indicate a yes or no.
Papa?
Thank you.
Yes.
Apologise, Your Honour. The application would be to tender that statement as an exhibit.
All right, it is tendered, and you made oral arguments yesterday, so we won't go through that again. We heard your arguments. The panel admits the written statement of Mr. Gashi in evidence under Rule 154 of the rules, except paragraphs 16, 32, 34, and now, in addition, 14 and 28, which are reserved for direct testimony. The panel notes that the SPO also objects to the admission under Rule 154 of paragraphs 20 and 22, submitting that the nature of the facts mentioned in these paragraphs are more appropriately adduced by the witness in the courtroom, and according to the principle of orality, it would be more appropriate to hear this evidence orally rather than simply introducing it in writing. The panel notes that the two paragraphs concern the alleged statement of an SPO investigator regarding the access of the Kosovo police to the seized documents and the possibility of retaining those documents for a month. Nothing in the wording of Rule 154 prohibits the admission of such facts through that provision. In fact, Rule 154 permits the admission of written statements that go to proof of the acts and conduct of the accused if the three conditions stated in the rule are met. In contrast, Rule 153 does not permit the admission of evidence concerning the acts and the conduct of the accused. The panel recognizes that certain parts of a Rule 154 statement may concern issues that are particularly contested. A calling party who submits a statement under this rule may, if it wishes, conduct an additional direct examination on any parts of the written statement, and the panel retains a discretion to order the calling party to conduct a direct examination of the witness on any.
The interpreters kindly ask His Honor to speak more slowly.
To exercise its discretion to order the Gucati defense as the calling party to conduct a direct examination on most of the paragraphs except as to the ones I just mentioned, which are 14 and 28. Moreover, the panel sees no merit in singling out paragraphs 20 and 22 rather than the others in the statement to advance an argument based on the principle of orality. If the SPO is not satisfied with the content or level of detail in those paragraphs, it can cross-examine the witness in that regard. The panel accordingly finds that the statement, including paragraphs 20 and 22 and 14 and 28, are relevant and have probative value as it goes to the acts and conduct of the accused in relation to the charges. The panel notes that Mr. Gashi is present in court and is available for cross-examination and questioning by the panel as well as the parties. He has also attested that the written statement accurately reflects what he would say in court, except paragraphs 14 and 28. The panel therefore admits the written paragraphs except 16, 32, and 34 with a public classification and also restricts admission of 14 and 28 as a written document under 154, but he may be subject to direct examination and cross-examination in this court. Madam Court Officer, please assign an exhibit number to this item and state it on the record.
Your Honor, the witness statement will receive exhibit number 1D9.
1D9 is admitted with the exceptions that I have noted. You may read the statement, Mr. Bowden.
Thank you,
And
Your
you
Honor.
may, as you suggested, you may pause at the appropriate time and question those particular paragraphs.
Thank you, Your Honour. The statement says as follows: I Chelgache will say as follows. I was born in Dobodol in the municipality of Podujeve, Kosovo. I was educated in the local school. I left in 1983, 1984. I now live in Pristina with my wife and my son. In 1983, 1984, together with a group of friends, I became actively involved in promoting the cause of Kosovo. In 1985, my cousin was a Yugoslav conscript who returned to his family dead. He was in a closed coffin. My family were instructed that under no circumstances should they open the coffin before burial. We ignored this and opened the coffin to view him and saw that he had been shot twice with a small entry wound and a large exit wound. It appears he was shot from behind. We as a family believed the Yugoslav army were responsible. In March 1987, I was conscripted for the Yugoslav army in Vranja in modern-day Serbia. I obviously believed that the same fate my cousin experienced awaited me. I was also aware of the case of Aziz Kelmendi, who was murdered. After his case, the Kosovan Albanian soldiers were treated differently. Frequent interrogations took place, and I felt I could be targeted at any time and harmed. Albanian soldiers were frequently woken and taken away for questioning by members of the Yugoslav army. All I wanted to do was to get through my conscription unscathed. The treatment of the Albanian soldiers increased my level of ideology for an independent Kosovo. In 1988, I was offered 3,000 Deutschmarks to become reactivated and take part in the war. I turned down this offer. In 1989 to 1990, Yugoslavia started to break up. At the time, I worked in a market in Pristina. I took part in student protests and strikes that were occurring. At this time, this was my only cause until I met my future wife. In the 1990s, Albanians were systematically dismissed from all forms of employment. On the 10th of February 1997, because of the friendship with Shea Rama, who was a high-ranking KLA member, I was initiated into the KLA. I have been an active member ever since. I took an oath with the Albanian flag. It was on this date that I first took up arms and became weaponized. We were viewed as liberators by the Serbs, who became our oppressors. I had lots of conflicts and problems with the Serbian police. We were under constant surveillance by the Serbs and in constant fear from being arrested or liquidation. In early 2017, I became a committee member of the Steering Council, 61 members from all municipalities, and a member of the Headship Committee, the inner circle of 23 members. At that time, I became a close associate of Hisni Gucati, and when he had just been elected as chairman of the War Veterans Association of the Kosovo Liberation KLA WVA, my branch of the WVA gave our vote en bloc to Hisni Gucati. On the 7th of September 2020, at approximately 10 a.m., I was with Hisni Gucati, Nazim Haradinaj, Fatun Klanaku, Taibi Miftari, and Elvir Gucati in the upstairs offices of the WVA. Taibi Miftari was very upset as a package had been delivered, and she thought that it might have been a bomb. She told us all that the package had been delivered, but she seemed very distressed. So we all left the office where we were to see what was going on. The scene was one of confusion. Some were saying that the package was a bomb, and this was causing a certain amount of panic. However, when Nazim went to have a look, we realized that the package was only papers. Once we knew this, the situation calmed down. I went to the reception area where I saw a box, slightly smaller than the size of a banana crate, which contained documents inside. These documents had Serbian writing on them, including Serbian names such as Vukovic. This name was not known to me. However, I saw this name numerous times because it was mentioned on numerous documents. Your Honor, if I may stop reading at this point. Mr. Gashi, is it true to say that at this time you remained in the company of Mr. Gucati, Mr. Haradinaj, and Mr. Klanaku?
Yes, that's true.
And you had with you the box with the papers?
Yes, that's right.
And looking at the content of those papers.
Yes.
Yourself read a few of those documents. Is that true?
Yes, that's correct.
How many documents you read and how long you took reading those documents?
I did not read all of them, but I did go through a few. It was a voluminous package.
When you say a few, could you give a more accurate figure to that? Was it perhaps 5, 10, 20?
$70 to $100, roughly.
How long did you take looking at these documents, time-wise?
It could be in parts. I went in and out because at the time I had to go to Taibe to check on her because she was scared.
On continuous period of time, it was shorter periods. When you add
That's correct. That's correct. It was done piecemeal.
The interpreters kindly ask the speakers to not overlap. Thank you.
I apologize.
30 to 40 minutes, roughly. I just cannot recall because it was done, as I say, piecemeal.
So 30 to 40 minutes in total.
Fairly possible. I'm not entirely certain because a long time has elapsed since, but it might well have been the case, yes.
Thank you, Mr. Gashi. Your Honour, may I continue reading?
Yes, you may.
The statement continues as follows. I thought to myself when looking at the box of documents, how could the SBO stoop to the level of Serbia? I was confused as to the purpose of the reason for the documents being delivered. We felt that the Kosovan public should be made aware of the contents of the box, so it would undermine the Kosovo Specialist Chambers, KSC, which is a body that we do not recognise as legitimate. We did not want to provide any names. We just wanted to tell the public that the information had been provided to The Hague by Serbia. On the 8th of September 2020, the following day, at approximately 11 a.m., I was having coffee with friends, but not at the WVA headquarters. I received a phone call asking me to return to the office, but I did not know why. When I returned, I saw 4 strangers in the headquarters. 2 I realized were from The Hague, and they were accompanied by 2 interpreters, 1 male and 1 female. The 2 interpreters introduced themselves and said that they were from The Hague. Pren Marashi, head of the WVA committee, was present at the time. One of the men from The Hague was Swedish, but Chinese-looking, and was seated. The other looked a bit tense, was fidgeting, restless, and refused to sit. I was sitting opposite him and could see that he was noticeably nervous. The man who was standing was confrontational. Faton Klenaka was present and insisted that the man sit down. The man said that he was providing security. In turn, Faton responded, saying that he could not provide security in our office. Eventually, the man sat down and the situation calmed down. They then both had a coffee with us. The men were asking for us to give them the documents. We were saying to the men that we would not give them the documents until we were able to speak to the Kosovan prosecutor. Once we spoke to him, then we would decide what we would do next. They continued to request the documents and we repeatedly denied them access. The Swedish SBO investigator then said, "We can stay here for 1 month, but no one will come from the prosecutor's office or the local police without our approval." At this time, when the SBO investigators were present, I said to Faton that they should look at the CCTV footage to identify the persons who made the drop-off. We then rang Hisni Gucati, who was in Albania at the time, who said that we should give them the CCTV footage. They then said that we could have the documents for a month, and then it was mentioned that the Kosovan prosecutor may be allowed to have access to the documents then. Either on the 14th or 15th of September 2020, we at the WVA decided that any further document delivery of this nature would be made public immediately. As far as I was aware, we put things out on Facebook to confirm this policy. As such, journalists would be invited via email to attend any future press conferences. On the 16th of September 2020, I was in the WVA offices with Taibbi Miftari and Elvia Gucati. I was sat in the office with the door open. I was aware of a person that had come into the offices and appeared at the door. He appeared confused and frustrated. I was the first to attend to the unknown man because Taibbi is a woman, so I did not want her to confront him. Taibbi was confused and frightened, and I was concerned for her welfare. My purpose was not to let him get inside our offices. The man was milling around from the canteen to the entrance to where our offices are. I wanted to prevent him from entering our office space. The unknown man came in holding a big box, which he then placed on the floor. When I went out to attend to the man, I was nearer to the man than the box itself. I did not interact with the man. Having dropped the box on the floor, the man then left by the same door and appeared confused as to the location of the exit. The man was masked, wearing gloves and all in dark clothing. It was impossible to make out any identifying features. The man then went towards the stairway and disappeared. Faton then chased after him, and I went after Faton as I feared for Faton's welfare. The man was too quick, however, and exited the building. We chased him down a couple of flights of stairs, but he was too quick for us. We did not follow him all the way down to the ground floor. Indeed, when we returned to our office, everyone said that we should not have endangered ourselves by chasing him at all. Faton and I went to look through the window, but could not see which way the man went. Once again, Your Honour, may I pause at this stage and clarify some matters with Mr. Gashi?
Yes, you may.
Mr. Gashi, at that stage, you were in the company of Mr. Hisni Gucati, Mr. Gucati&Haradinaj, and Mr. Faton Klinaku. Is that correct?
Yes, that's correct.
Box of papers that had been delivered by this unknown man were taken into Mr. Hisni Gucati's office. Is that correct?
Yes.
You looked through those documents. Is that correct?
Yes.
Like the previous delivery, can you remember how many documents you yourself looked at?
I cannot say exactly because Taibbi, in fact, was utterly distressed, so I had to go to her to try to calm her down. We were, in a way, more concerned about her well-being than the documentation that had arrived. She was really stressed out, and we had to go to her to try to reassure her and give her a bit of water so she calms down.
You weren't spending one continuous period looking at the documents. It was piecemeal. Is that?
Yes.
Mate, for how long altogether you were looking at the documents?
You mean generally every time we had the delivery, or about this particular package? 10, 15, 20 minutes. I cannot recall exactly, but time was limited. Time that we had available was limited.
You can't recall how many documents you looked at?
Can I speak? I've seen Vukcevic's name in the Serbian language. I wasn't fully aware of who he was, but I've seen a few credential papers exchanged between Vukcevic and the SBO.
Your Honour, may I continue reading the remainder of the statement?
Yes, you may.
The statement continues, we had already made a collective decision on either 14th or 15th of September that if there were any more drop-offs, then a press conference was to be called and the public informed of the contents of the box and documents. So this is what we did. On the 22nd of September 2020, together with Emin Lati, I was in the conference room at the top floor of the WVA building when I heard a commotion downstairs in the WVA offices. I went down and I could see that Tayabi was upset, so I tried to calm her down. She told me, and I am now aware, that a male had attended the offices and produced documents which he had thrown to the floor. I had a quick look at the documents, which appeared to be indictments and were in English. I knew the names in the indictment, and I felt overwhelmed as they were my heroes and selfless in the cause. I felt that this was a Serbian deed. After the detention of Hisni Gucati in approximately mid-May 2021, I saw his elderly parents whilst at the museum, and I felt bad for them. I am willing to come and testify at the KSC in The Hague. That is the end of the statement, Your Honour.
Microphone, please.
No, Your Honour.
Thank you, Mr. Bowden.
Thank you.
Mr. Warboys, any questions?
Nothing now, Your Honour, thank you.
Thank you. Mr. Howling, cross-examination.
Thank you, Your Honor. Good morning, Mr. Gashi. My name is Matt Halling, and I'm an associate prosecutor with the SBO. I'll be asking you some questions this morning. Your statement that was just read out in summary to you, you signed that on 15 July of this year, is that right?
Yes.
And in the statement that you signed, at paragraph 14, you said you took approximately 2 to 3 hours to review the first batch of materials sent to the War Veterans Association. Isn't that right?
I think it's a mistake when it was translated.
The statement on 15 July is in Albanian, isn't it?
Yes.
Speak Albanian?
Yes, I do.
So, did you review the statement before signing it?
I did, yes.
And in paragraph 28 of the statement you reviewed and signed, you also said you reviewed the second batch of materials for up to 4 hours. Isn't that right?
I think it's a mistake in both cases about the time. Because it was a short time. I couldn't have 4 hours at my disposal. When the media was called, I think just 1 hour passed from the first moment, so I didn't have 4 hours. This proves it.
On 6 September 2021, You signed the English translation of this same statement. Isn't that right?
Pa,
Yes.
jo.
No.
Read back to you before you signed it?
Më ka lexu pa.
It was read back to me. But when I came here, I wanted them to be improved.
Fillim pak po në zdeshta më ndryshë se shkolla është kërpe me, pa unë.
I didn't want to go into details initially, but as I said, some minor mistakes were made.
Did you make any corrections to your 6 September 2021 statement after it was read back to you?
Kam bo, po që
I did, but yesterday when I read it, I noticed these minor mistakes.
Who read the statement back to you on 6 September?
kam lexu vetëm.
I read it myself. Why should anyone read it out to me?
S'ta shurma këtu.
When I came here, I found out that there were some technical mistakes in it.
Now I'm talking about the English translation of your statement, and you said that someone read it back to you before you signed it. My question is, who read it back to you on 6 September?
Është kom admire.
Admir. When I came here, he translated it to me because I don't speak English.
Did you indicate any corrections at that time to Admir?
Po dy herë kem bo korrigjim se
2 corrections were made. The mistake was there. Well, I don't think the words are very well found, very adequate. I said that there are a few mistakes in translation.
So I'm correct that the 2 mistakes that you identified today, you identified with Admir on 6 September 2021.
jo.
No, now that I'm here.
I'm talking about on 6 September 2021. My question is, on that date, did you communicate the same corrections you've indicated just now?
Disa kem bo, po këto ja.
Some were corrected, but not these ones. But now I realized there is something about the school I did in my village, and this is not mentioned here. 2 years in Podoyev, 2 in my village, and that was not reflected here. And I wanted them to be amended.
Is the summary that Mr. Bowden read just now about your years in school accurate?
Sakt po shkolla ku
Accurate, but the school that I went, there were 2 different schools. The first 2 years I did in Kirpime. The third and the fourth in Poduyev. It is written there that I went to the other village. It's wrong. Only 2 years of high school I did in my village and 2 in Poduyev.
So is paragraph 1 of the statement read to you just now accurate or not, as Mr. Bowden read it to you?
dyse. Bëmirës më falë?
Can I read it? Can I?
Yes.
Yes.
Në Dobërdan në komunë.
I was born in Dobërdan, Podujeva Commune. I went to the local school. The local school is in Dobërdan. I moved in 83, 84. It should be 2 years. I did them in Kirpimer, in the high school. Then in Poduyev. That is altogether 4 years. It's not written there at all. It's not mentioned, my schooling.
And you indicated that on 6 September 2021.
E kom thonë, po,
Yes, I did. But I don't know how it happened that it's not reflected. I said it. That this is where I did the school. There, I couldn't say. I mentioned another name.
Presented with an amended version of your 15 July statement with this amendment incorporated.
ma herë të konë ka
There was something, but not everything. So the mistake consists in the fact of my schooling, my education.
Were the comments that you gave today about how long you reviewed the first and second batches, did you indicate those corrections on 6 September 2021?
paketjen gjitha.
Yes, yes, but I can't explain how it came about that they are not there. I explained about my school, but I can't know how it came about. I couldn't deny where I went to school. It seemed as if I have done only the elementary school and nothing more.
Mr. Gashi,
Po,
when you were read on 6 September 2021, this quote, "I spent 2 or 3 hours reviewing the documents," did you inform the member of the defense you were speaking to that that was incorrect?
unë në qatë ku në këna thonë, po tash
I did.
Presented an amended version of your 15 July 2021 statement in Albanian with that fact corrected.
më ka thonë anglisht.
It was given to me in English. At the end, it was in English.
So your Albanian statement of 15 July 2021 was never amended after you signed it. Isn't that right?
Jo, masë që sa që
After I signed it, no.
And when that same member of the defense read you from paragraph 28, we then went through the documents, although admittedly not all of them, for up to 4 hours. Did you indicate that correction on 6 September 2021?
nuk më kujtohet ta kom thonë.
I don't remember if I did.
Gabim,
But when I came here, I've identified those mistakes and I presented them.
në banja.
You can do as you like, it's not a problem for me.
You had a preparation session with the Gucati defense this week, isn't that correct?
Ja, jem taku këtoa,
Here? You mean here?
7 December,
Po.
is that right?
Yes, yes.
Did you review your statement at that preparation session?
pra ja, se kom këshyrë thonë.
No, I didn't see them. Because it was a very short meeting, 5 minutes.
Did you review your statement before that preparation session?
Stashën se dy ditë kam pa këto këshyra kur
When I looked at it, I found out that there were mistakes.
When did you look at it before the preparation session?
dia pardje kam po.
Yesterday or the day before, I think. I can't be accurate. I read it and I saw that my education was not there, and the mistakes that I mentioned.
Mr. Gashi, I'd like to read to you part of an email from the Gucati defense. It was sent on 7 December 2021 at 8:14, and it's in relation to this preparation session. I said the session was on the 7th. The email says it was on the evening of the 6th of December. Please listen to what I'm about to read, and then I'll have a couple of questions for you. On Monday, 6 December 2021, Hugh Bowden, co-counsel, Eleanor Stevenson, co-counsel, and Murem Halilai, team member, held a witness preparation session with DW 1245 Seligashi at the premises of the Kosovo Specialist Chambers, The Hague, between 7:25 and 7:45. The statement of DW 1245, exhibited as DHG 0190 to DHG 0194, was formally disclosed, Disclosure Package 64, and in accordance with the trial panel's guidance concerning admission of material pursuant to Rule 154, the clarification, changes, or corrections which the witness makes are as follows. The witness confirmed that the content of his statement was accurate and no alterations or amendments to the statement were necessary. Mr. Gashi, does that accurately reflect what you said during the preparation session?
Si që kam thonë, po unë kur era
I may have said it, but when I came and saw it, it was with mistakes. Yesterday or the day before I saw it.
Mistakes to the Gucati defense at this preparation session?
fillimisht
Initially, there were even more mistakes. They were corrected 2 or 3 times. There were several technical mistakes. Always there were mistakes.
Mr. Gashi, isn't it true that the 2 to 3 hour estimate that you gave in July and September and 6 December, that you reviewed the first batch of materials to 2 to 3 hours, is what you actually remember for how long you reviewed that batch?
unë po të them për
No, 4 times it was impossible during the second time. I think 1 hour or 1 hour and a half, because we call the media. It says 4 hours. No, it was impossible for me to have 4 hours during the second batch.
I asked the question in relation to the first batch. I'll repeat it.
Well,
Mr. Gashi, isn't it true that the 2 to 3 hour estimate that you gave in July and September and 6 December, that you reviewed the first batch of materials for 2 to 3 hours, is what you actually remember for how long you reviewed that batch? Please answer that question.
s'kam mund të më kona shumë s'bes.
No, I don't think it was that long, because there were other things to do, technical issues. I don't think I spent so much time.
And in relation to the second batch, You just said now that it might have been an hour and a half that you reviewed the materials. You said earlier today it was 10, 15, or 20 minutes. Which is it?
Ja, ja. Nog daar is dan.
No, I didn't say that. I said after 1.5 hours, the media representatives came. There it's written 4 hours. Isn't it 4 hours there? I didn't have 4 hours, but the media came after 1.5 hours, and I couldn't read them when the media were there. So that's why I say it's impossible for me to have said 4 hours. Look at yourself. Sorry, look at yourself.
Mr. Gashi, as of this moment, what is your estimate of how long you reviewed the second batch of materials? How long was that time?
За 30 минути.
20, 30 minutes. I don't think more. Just I lived through them as much as I could.
Can you give any explanation for why the first time those numbers were introduced as evidence was this morning?
Today I had the opportunity to meet with you.
So you gave these estimates, these corrections this morning, because now you're talking with me. Is that your answer?
Yes, yes.
Mr. Gashi, you said this morning that you reviewed somewhere between 70 to 100 documents when reviewing the second batch. Is that right?
I just lived through, as I said.
70 to 100 documents in relation to the second batch or the first batch that you reviewed?
I can't be sure whether it was the first or the second. I'm not sure, but most probably the second.
Can you explain why that isn't in your statement?
What are you saying? I mentioned somewhere in my statement that I looked at them.
Did you indicate how many documents you reviewed when your statement was taken?
I didn't look at them carefully. I just lived through them. Some of them didn't seem relevant to me, so I just gave it up.
Mr. Gashi, that wasn't my question. Did you indicate how many documents you reviewed when your statement was taken? Could you please answer that question?
Yes, I looked at them, but very quickly.
Assistance, if that question could be directed from the judges to the witness. Thank
you. Mr. Gashi, you need to answer the question as it is asked. You were asked, did you indicate how many documents you reviewed when your statement was taken? Please answer that. Did you make that statement?
já está desde 20.
I said about 70. I looked at them. I just lived through them. Microphone, please. Microphone, please.
Did you indicate how many documents you reviewed when your statement was taken, the day you took your statement?
Já
60, 70, I said approximately.
The day your statement was given?
måste konfirmera mest para måste kon.
Are you talking about the first batch?
Mr. Bowden, could you please direct your client to answer that question?
Your Honour, could I perhaps make this point, that paragraph 14, of course, was not read this morning, and whether or not the content of paragraph 14, it would be fair to remind Mr. Gashi of, in those circumstances, as to the number of documents that were read. Because it is indicated in paragraph 14.
We need to get the answer from him on this question first. Then if you want to clarify, you can.
Your Honour, he's been asked as to the content of the statement that he gave to his representatives, and the content of that statement, of course, has not been specifically referred to, and we have paragraph 14 that he could be referred to.
Was 14 left out this morning, or was it read?
It was left out this morning. There is actually not a number in that paragraph.
That's my understanding as well.
Well, Your Honour, we're entering the realms of a
All
couple and a few, and there is reference to.
That's all, Mr. Bowden. Mr. Gashi, I expect you to give us an answer. On the day you made your statement, did you say that you had read 70 to 100 pages?
I don't think so.
Your Honor, I note that it's 3 minutes to 11. Now would be a good time to break for purposes of our questioning. If you would like, the break could be taken now.
How much longer will you be, Mr. Helling?
I expect to finish in the first half of the next session.
Okay. Thank you very much. We will break at this time, be back at 11:30. Please escort the witness.
All right. All rise. It is.
Please be seated. You may continue, Mr. Helling.
I'd love to, Your
Oh,
Honor.
we don't
but
have a witness.
We
That's
misplaced the
difficult.
witness.
Anyway.
Can you hear Mr. Gashi? Mr. Helling, you may continue.
Thank you, Your Honor. Mr. Gashi, now I would like to take you to 8 September 2020. This is the day after the first batch of materials was delivered to the War Veterans Association. You said in your statement that you were at the office and the SPO was there, and you said that you were speaking with a Swedish man from the SPO. Why was the SPO at your office that day?
Microphone, please.
None. Please repeat your answer.
There is
We understood that they had arrived, but the interpreters told us.
The SPO came back to take the documents delivered on the 7th. Isn't that right?
Yes.
With a court order for this purpose. Isn't that right?
Yes. Later.
And for a while, the documents were not given back because you wanted to give them to the Kosovo prosecutor. Is that correct?
That's correct. It's true.
According to paragraph 20 of your statement, we can stay here for 1 month, but no one will come from the Kosovo prosecutor's office or the local police without our approval. Is that correct?
That's right.
This discussion, there was a kind of standoff going on in relation to the documents, such that you didn't want to give them back to the SPO. Is that right?
We wanted the Kosovo prosecution's office to be there, yes.
Did the SPO say at any point during this interaction that the War Veterans Association could keep the documents?
Yeah.
No. They said you may keep them, but literally they said you may call the Kosovo prosecutors, but they wouldn't be able to come here without our permission, even if we were to stay here for 40 days.
And the SPO didn't leave that day until they'd taken the documents from you. Isn't that right?
That's right.
Batches were delivered on 16 and 22 September. The SPO came and took those documents back too. Isn't that right?
Yes.
Mr. Gashi, in the course of this week, did you watch any of the evidence of the other defense witnesses in this case?
You mean here?
Here, this week, as other evidence was presented, did you watch that evidence be presented on video?
Ato këtë televizor nuk
We have no TV at the place we're staying. Some fragments here and there on the phone. Yes, that is the case.
You say fragments here or there on the phone, so that means you were watching the court hearing on your phone at times this week. Is that correct?
jo kretë.
Not all of it. Brief excerpts.
Are you aware that during the course of this week there's been testimony as to how long batches of materials were reviewed at the WVA before the press conferences?
Apo në pyetën fal.
Can you repeat the question, please?
Are you aware that during the course of this week there's been testimony as to how long batches of materials were reviewed at the War Veterans Association before the press conferences?
Jo,
No, I don't think so. I haven't seen.
You recently had a meeting with many of the defense witnesses in this case. Isn't that right?
po.
Yes.
And isn't it correct that you consider yourself to be a supporter of the accused in this case?
Mendon për këta dy
You mean these two here?
Right.
e mbështes.
Yes, I do support them.
And that's in fact why you're here today, to support the accused in this case.
Yes.
3 batches that were given to the War Veterans Association, you wanted them to be given to the press. Isn't that right?
Po.
Yes.
Undermine the Kosovo specialist chambers. Isn't that right?
Jo me cenu,
Not to threaten them, but to bring to light the cooperation of the specialist chambers with the Serbian regime. Their cooperation between the specialist, the prosecutor's office at the specialist chambers and Serbia.
Mr. Gashi, please answer the question as I've asked it. You wanted to undermine the Kosovo specialist chambers. Isn't that right?
Unë thash mendimin
I give you my opinion.
Please answer that question with a yes or a no. You wanted to undermine the Kosovo specialist chambers. Isn't that right?
na vetëm drejtën.
We just wanted to tell the truth.
Your Honors, if I could please ask the indulgence of the court to ask that question.
That question, Mr. Gashi, calls for a yes or no answer. You can use either one. Do you need to have this question asked again? Mr. Halling, ask the question again, please.
Certainly, Your Honor. You wanted to undermine the Kosovo specialist chambers. Isn't that right?
Unë nuk kam dëshiruar, po
I didn't want to. You did the undermining by taking materials from Serbia. There's nothing else to add here.
ajo përmes SPV-sorëve
The materials came to us via the SBO. I did not send those batches there.
Mr. Gashi, you said the following at paragraph 15 of your statement. We felt that the Kosovan public should be made aware of the contents of the box, as it would undermine the Kosovo Specialist Chambers, which is a body that we do not recognize as legitimate. That's still how you feel, isn't it?
Po, më mend-
Yes, that's how I feel, yes.
Thank you, Mr. Howling. Any redirect, Mr. Dowd?
Your Honour, if I may ask just two questions resulting from the cross-examination.
Yes, go ahead.
And they relate, Mr. Gashi, to the evidence that you've given about the 7th of September and the 16th of September. Am I correct in saying that there are two periods of time on both of those days?
Your Honor, that question is vague as phrased. Maybe it's possible to
I've not got to
reformulate
the
it.
question
He hasn't
yet.
finished the question yet.
Apologies.
The first period of time being the total period of time between when the batch arrived at the WVA offices and the calling of a press conference. That's the first period of time. Is that correct? So it starts from the arrival of the documents, it goes on until the calling of the press conference, and that will be a clearly recorded period of time. Is that correct?
Po.
Yes.
And then there's a second period of time, which was the actual period during that time that you spent looking at the documents.
Det var det.
And
That's correct.
are not the same.
Jo.
They are not.
To make.
Po.
Yes.
Thank you. Mr. Warboy, anything further?
I don't think so, Your Honour, but I'm slightly confused on the answer. No,
If you-
no, thank you, Your Honour.
If you want to step back and consult with your client?
It's fine. I've got the instructions.
Okay.
Thank you, Your Honour.
Nothing further, Your Honor.
Thank you. Anything from the panel? Mr. Gashi, this concludes your testimony. You may leave now. Thank you for being with us. All right, in relation to the further examination by Mr. Rees of the SBO witnesses and the SBO's request in this regard, the panel decides as follows. The panel grants the request of the Gucati defense to further cross-examine witnesses 4841 and 4842 for the following reasons. The delayed disclosure of the items concerned is the result of the fact that the prosecution resisted disclosing these to the defense and sought an order from the panel not to disclose these. Furthermore, the panel deferred its decision on inter alia item 191 and items 195 to 200 to the end of the SBO case, as it wanted the benefit from the evidence adduced during that case before deciding on this issue. The issue regarding items 201 and 202 arose later on, with decisions rendered in mid-November and again this week. Accordingly, the items that were ordered to be disclosed reached the defense after the close of the prosecution case and could not be used by the defense at the time they cross-examined those witnesses during the prosecution case. Furthermore, the panel notes that the SBO's argument on the effect of the evidence recently heard on the entrapment allegations but a decision on this matter will be rendered in the judgment once all of the evidence has been heard and not at this stage. The panel is mindful, however, that these witnesses are being called after the SBO's case is closed, further to the panel's indication that it will entertain such a request, and the information in Rule 102, subparagraph 3 materials is highly sensitive as it is said to relate to ongoing SBO investigations. The panel notes, however, that there is no requirement in the rules nor in the order on the conduct of the proceedings for the cross-examining party to provide a summary in advance to the opposing party of the areas on which it proposes to cross-examine a witness. For these reasons, the panel orders the defense to ask its questions with the following limitations. Questions as to any other topic than the materials disclosed pursuant to decisions F-413 and F-435 are not permitted. While the defense is not required to provide in advance a summary of their intended questioning, the defense should be ready to explain the relevance of any line of questioning pertaining to these documents. Pursuant to Rule 120, for purposes of security, non-disclosure of the identity of witnesses, and the interest of justice, the defense is directed to conduct its cross-examination in private session. The panel will, in due course, review the transcript and order reclassification if appropriate. Noting the SBO's indication that the two witnesses are available next week from Wednesday to Friday, the panel expects to have them here for questioning on Wednesday, 15 December in the morning. The defense is asked to provide the panel and the SBO with an estimate of the amount of time it expected will be needed for the further cross-examination of each witness by 13 December 2021 at 4 p.m., unless such an estimate can be provided today. That concludes the oral orders. Mr. Reese, can you provide an estimate today, or do you prefer to make use of the deadline we just set?
No, I'm happy to say that I do not envisage cross-examination for either taking more than half an hour.
Thank you. Now, as to some housekeeping matters. Mr. Reese, we have been informed by the registry that your next witness, Mr. Faik Fazliou, has not yet arrived to The Hague and is not available to testify today. We would want to start and conclude his testimony on Wednesday. Can you give us any information on this?
Can I assist in this way? We've obviously dealt with the bulk of the defence case. We're at a stage now where we will revisit the extent to which we regard it as necessary or of assistance to call any further evidence in terms of witnesses. We will update the court as soon as a final decision has been made about that. There are further administrative matters that we require to take place before we reach the position where we can formally close the case, and not least dealing with the two witnesses who are to be recalled, which Your Honour's just referred to. There will also be a request for omission of items through the bar table and related matters submitted pursuant to the direction this afternoon. And we also envisage seeking to perfect proposed agreed facts with the SPO again before we formally close our case. We will obviously consider whether we're able to do that next week. If we're not formally able to, or we feel that that's our position, we'll address the trial panel at that stage. But we're conscious that progress needs to be made with Mr. Haradinaj's case, and the trial panel has given directions as to the commencement of calling evidence by the Haradinaj defence next week. And certainly we don't envisage anything holding up the commencement of the Haradinaj case, whether or not we seek extension of time before formally closing our case. But we'll deal with those matters next week. Returning back to the witness you specifically named, Your Honour, I hope Your Honour will have picked up that as we are reviewing our case and whether there is any necessity to call further witnesses, it may be that there's no further oral evidence that we seek to call other than dealing with the cross-examination of Ms. Pumper and Ms. Dukic on Wednesday morning.
All right, thank you. Mr. Reese, we would like to have a little more advance notice on this last witness, maybe by Tuesday?
Certainly.
Okay. And then secondly, we would like you to be in a position to close your case at the end of the examination of those two, the cross-examination of those two witnesses, save the fact that you may have a bar table motion that we could consider on paper later on. We'd like to get this matter moving on, and we'd like to take the next step to the Haradinaj defense, with you having rested. Is that going to be possible? Or you could get the bar table motion to us right away, and we could start dealing with it.
I certainly understand the court's position, and we will look to be in a position to close our case as soon as we can. We are conscious that the SPO has an ongoing disclosure obligation that doesn't complete, it doesn't end at any point. And we are conscious that the closing of the evidential proceedings is likely to be sometime after the end of next week, for example. So it may be that in due course next week, we seek the indulgence of the trial panel to, for example, permit ongoing discussions about proposed agreed facts that might be concluded at any point before the end of evidential proceedings, whether or not a party's case is closed, for example. Can I address the trial panel again in relation to that, acknowledging the trial panel wishes us to be in a position to close our case formally next week?
Yes, you may, but bear that in mind, and so that we are able to discuss it with some sort of timetable when you come back to the court.
Understand.
Secondly, we haven't resolved witness 1248 and whether or not that's going to be adopted as agreed facts or what.
So in relation to the witness statement of Mr. Bowden and his exhibits, as part of the draft filing that we will file this afternoon for the effectively the bar table motion, we will indicate that we will seek admission of his statement and exhibits pursuant to Rule 153 as invited to do so by the SPO. It seems to us to be the most straightforward way of dealing with it in the circumstances.
And I assume the prosecution still has no objection to that admission?
That's correct, Your Honor.
Okay, that's great. Thank you. I'm sorry, do you have any objection to what Mr. Reese just discussed?
No, none, Your Honor.
right.
Thank you.
Mr. Reese, if you wish, you can just offer the Mr. Bowden testimony. At this time, there is no objection. We can admit it.
I offer it, the statement and the exhibits to
All
the
right.
statement.
Can you give us a number for the statement and exhibits for Mr. Bowden's? Rule 153 admission?
If it assists.
No, I'm asking the court officer.
I can assist with identifying the DHG number for both the statement and the exhibits. The statement is actually the draft cannot be correct, I'm afraid, so I'm not sure I can assist right now. So the statement is DHG 0447 to DHG 0449. The exhibits referred to therein are DHG 0392 to DHG 0404, DHG 0444 to DHG 0446, DHG 0431 to DHG 0443, DHG 0405 to DHG 0418, DHG 0419 to DHG 0430, DHG 0390 to DHG 0391, DHG 0388 to DHG 0389, and DHG 0364 to DHG 0387. It may make sense if a single P number is given for that, the statement and the exhibits together. I see Madam Court Officer shaking her head. I'll leave it to Madam Court Officer then to wrestle with the technicalities.
Your Honors, the documents in the order as read by Mr. Rees, DHG 0447 to DHG 0449 will be Exhibit 1D10. DHG 0392 to DHG 0404 will be Exhibit 1D11. DHG 0444 to DHG 0446 will be Exhibit 1D12. DHG 0431 to DHG 0443 will be Exhibit 1D13. DHG 0405 to DHG 0418 will be Exhibit 1D14. DHG 0419 to DHG 0430 will be Exhibit 1D15. DHG 0390 to DHG 0391 will be Exhibit 1D16. 16, DHG 0388 to DHG 0389 will be Exhibit 1D17, and DHG 0364 to DHG 0387 will be Exhibit 1D18. Thank you, Your Honors.
So exhibits 1D10 through 1D18 are admitted through Rule 153, satisfying Rule 138 for admissibility. Thank you, Mr. Rees.
Thank you, Your Honor.
All right, moving on to the Haradinaj defense. Just to put it on the record, the panel reclassified as confidential Annex 2 of F-471, which is the summary of the evidence of Mr. Haradinaj. Mr. Warboys, your team filed a summary of your client's evidence on the 3rd of December. At that time, Mr. Cadman indicated to the panel that the document was filed as a summary because Mr. Haradinaj was in quarantine and could not sign a proper statement. Do you still intend to file a signed statement, and if so, when, given that your client is sitting here in the courtroom?
Your Honour, thank you for raising that matter. It's something that I have been speaking with the prosecution about this morning. I'm sure they'll correct me if I misrepresent anything. The position is I haven't been in touch with Mr. Cadman much at all over the last 48 hours because he is significantly unwell. What I've proposed to the prosecution is that we will provide them with an update by Monday latest as to exactly what the position is, but ideally over the weekend. I can only apologise for the fact that is where I am right now, but I'm sure you can appreciate I have stepped in and appearing before you somewhat last-minute notice, and we are moving forward in the best way that's possible.
While you're at it, it would be good by Monday to indicate whether Mr. Haradinaj intends to testify as a Rule 154 witness or not. And I'm sure the prosecution and Mr. Rees would appreciate knowing that.
That's understood, Your
So let's say Monday by noon you will have filed something to let us know.
We will let you know the position by Monday noon. And it is understood on the 154 position. That is also something that I have discussed with the SPO this morning. So thank you, Your Honour.
You've discussed but not decided.
No, I've preemptively raised the issue this morning,
Okay.
and we have agreed a way forward which reflects what, Your Honour, you have said as well.
And do you have an answer for us which of the two witnesses will be called next week?
Yes, scheduling, well, it should be 12:54 as well.
I believe that's all for you, Mr. Warboys. Thank you.
Your Honour, there is one other matter which, again, and I'm raising it now, mindful of the fact that I've only been on my feet here this week with this. On the examination of the recalled witnesses, my understanding is that there is a deadline of today to file any applications. We obviously would hope not to ask any questions in cross-examination and simply to adopt the position that the Gucati defence takes. The direction I would seek is whether we would need to submit a formal application to be able to rely on or adopt the position which they take, or whether I can deal with it orally now, Your Honours.
As far as you can deal with that orally if you wish to.
Thank you. Well, in that case, Your Honours, we would seek to also have leave to cross-examine the further witnesses. I would hope that, the former witnesses, I would hope there would be no questions to ask and we can simply adopt the position adopted by the Gucati defence.
Any problem with that, Mr. Holling?
No problem with that, Your Honor. The only thing we would say in response to what Mr. Warboys has just said is that we appreciate the difficulties the Haradinaj defense have had recently. We really do require a statement for our preparations if one is being given. It is already late. So we appreciate that Monday an update will be given, but if a statement is being provided, we would ask that it be provided by next Wednesday at the latest.
That's a reasonable request, and Mr. Warboys, that will be what you're ordered to do.
Yeah, yes, Your Honour, that's understood, and it also reflects the discussions which I've had with the SPA.
Thank you. In any case, the defense for Mr. Haradinaj should be ready to have its opening statement on Wednesday, the 15th of December. We don't know at this point whether we can get to it on Wednesday, depending on the witnesses still to be heard, but if we can, we will have your opening on that day and start the evidence on Thursday, the 16th of December. If the Wednesday witnesses take up both the morning sessions, we will have the Haradinaj defense opening statement on Thursday morning with the evidence starting immediately afterwards. Understood?
Your Honour, that is fully understood,
Okay,
and
thank you.
I'm prepared.
Anything else to be brought to our attention? Thank you for your attendance. This was a long week, and I think we accomplished quite a bit altogether, so thank you for that cooperation. Thank you to the translators and court reporters and security personnel for all of their efforts. We'll see you Wednesday morning at 9:30.
All rise.